Good morning, I'm Dan DeRose with 19 News Now, coming to you from our digital desk. We are going to begin our gavel-to-gavel coverage of a trial taking place in Summit County. It has been dubbed Deadly Delivery. It is a case that actually stretches back to 2012. The woman you see sitting in the gray with the glasses, there you go, that is Erica Stefanko. This is a little bit of a convoluted case. It is a love triangle, so to speak. Stefanko was married to a man named Chad Cobb back in 2012. Cobb was going through a nasty custody battle for his daughter with a previous woman, Ashley Biggs. Ashley Biggs was a former Army military veteran, and because this battle was ongoing, a plan developed where the woman you see sitting there, Erica Stefanko, and her husband, Chad Cobb, Erica Stefanko made the phone call that lured Ashley Biggs. She was a Domino's pizza delivery driver. They lured her to a vacant business with the fake pizza order. Chad Cobb has already been convicted for his role. He used a taser on his ex-wife and then beat and killed her. Put her back in her delivery vehicle, drove her to the middle of nowhere, dumped her body in her car, and then he called his wife, the woman you see sitting there, Erica Stefanko, and had her come pick him up. She picks him up, she helps clean him up and get rid of the evidence. Now, the reason I'm speaking as if she did this is that she has already been tried and convicted. She was tried in 2021. Her husband took a plea deal back in 2012. He was almost assured looking at a death penalty because this was pre-planned. There was premeditation. They lured her there. They killed her. Then he took her body out into the middle of nowhere. He took a plea deal almost immediately to get just life in prison. It would be 7 years. It would be 2019 before the prosecutor in Summit County brings charges against Erica Stefanko, the woman you see sitting there, for her role in all of this. Remember, in the state of Ohio, it doesn't matter if you're the getaway driver. If you are there in the commission of a crime, if you're the person who places the phone call and that person ends up getting murdered, well, then you can be charged with murder yourself. She was charged in 2019. Her trial was in 2021. Think about 2021. We were battling COVID. During her trial, it looks like we're getting our first sidebar because this is going to be complicated. Because during her trial, in which she was found guilty by a jury, her husband, now ex-husband, who was sitting in prison for life, Chad Cobb, he testified against her. But he did so wearing a mask because it was COVID, and he did so via video. And so when when Erica Stefanko, the woman you see sitting there, she was sentenced to prison, she was sitting in prison, and her attorneys filed an appeal. And they won based on the fact that her husband testified from prison with a mask on. He wasn't present in court, didn't have the chance to confront him in court. And so they said Erica Stefanko deserves a new trial. She has been sitting in prison since. The way this works is a new bond was placed. It was a $2 million bond. She clearly, apparently couldn't afford it or any family members because she has been continuously locked up. Now she is in court for her retrial wearing civilian clothes. You can't bring someone in a prison jumpsuit in front of a jury because that makes them appear to be guilty before the trial even starts. So she gets to wear civilian clothing. Now, what will be interesting during this trial, which as you can see has not started, we are in a sidebar, what will be interesting and tough for both the prosecution and the defense is you cannot bring up to the jury that there has already been a trial. You cannot tell the jury that Erica Stefanko has already been found guilty once, so you need to find her guilty twice. This needs to start from scratch. There can be no mention of the previous conviction. And that's probably, I'm sure the judge and the attorneys in this case have had several conversations. I'm assuming that's why they're having another sidebar to just remember that you cannot say, let's remember, in the first time she was tried, she was convicted. That would put this whole process in jeopardy, and it would have to start all over again. While we wait, let's take a listen. My coworker, Jeff Slauson, late last week did an interview with a Case Western Reserve University professor on this topic of retrials. You will not miss a second when this trial begins. We will come back. We are committed to gavel coverage throughout this entire trial. We can tell you Court TV is in town for this. 48 Hours is in town for this trial. This is a love triangle gone bad. Again, it is gavel coverage of deadly delivery. Let's listen to this now explanation of why we have to have a retrial for Erica Stefanko.
Explain to people a retrial as opposed to a more traditional normal trial that people would think of.
Sure. Well, a retrial starts by definition with a normal trial. Something happens along the way in the course of a normal trial. Either the trial gets interrupted by something or it gets overturned on appeal. And the result of that appellate ruling is that the defendant gets a new trial and that the guilty verdict that the jury reached the first time around is set aside for some reason. It can be an evidentiary reason, it can be a change in the law, it can be any number of things. So when the case goes back down from the Court of Appeals to the trial court, since the original conviction is no longer there, the only way to determine the guilt or innocence of the defendant is to have a second trial, a retrial, and then to determine in that retrial what the result will be, and the results of the first trial then become irrelevant.
So you have a situation where everything's happened, you've kind of gone through it. Are you using the exact same witnesses, the exact same evidence? I mean, how different are the two trials going to be? Or if it really is, by the name of a retrial, is it just the exact same thing done again?
That is a strategic decision for the lawyers to make. And it partly depends on what caused the retrial to be necessary. So, for example, I teach in an appellate litigation clinic where my students work on criminal appeals all the time. And in one of our cases, the client got a retrial because the jury was hung the first time around. So the second time around, there's very clear indications that the prosecution went out of its way in the retrial to do a better job of convincing the jury than it had done the first time. And lo and behold, in the second trial, they got at least one of the charges convicted. So partly it's strategic by the lawyers. What did I do last time that caused the problem? What did I do last time that I could do better this time? Partly it's just about the availability of the witnesses, because that always can change between the time of the first trial and a retrial. And then there is the very common occurrence, which is the same witnesses get called and give similar testimony the first time around. Big difference is the second time around, we already know what they said at the first trial, so we can be more selective about what we ask them. And they're locked into that testimony from the first trial. So if they try to change their stories, they can easily be impeached by the prior sworn testimony.
When you have a situation where it's a highly profiled or highly covered story, for instance, for the one that we're going to be doing here, how difficult is it then for something like a jury selection when the whole trial's been done, there was a verdict read, and now it's being done again? How difficult is that to find people that have no bias on it when there was already, I guess you could say, a bias revealed?
So the best person you might want to ask that question of is Dr. Sam Shepard, who was convicted here in Cleveland of a murder of his wife. And then because of the pretrial publicity at the time, the newspapers were all over the case, the Supreme Court said he didn't get a fair trial, that the jury had been compromised. So they tried him again here in Cuyahoga County after the Supreme Court said it had to be retried. And, it's always the case that when any case is high profile, it's getting covered on the news. It might have been covered on the news the first time. There is a risk that your jury veneer, or the group of people that come to court to see if they are going to be picked to serve on the jury, they can be compromised. And so it's very, very important for the trial court and for the lawyers to do a very careful screening of the potential jurors to see what they do and don't know from the last time. And also, if they do know things, to get them to agree to be able to set aside whatever they may have, opinions they may have formed, so that they approach the new trial without any bias or prejudice.
When you have a situation as well where this one is being brought to a retrial for basically they had it was done during COVID, the original trial, and the complaints were that the main witness in this was masked and not present. He was virtually there because he was in prison. Very specific, it seems, very specific reasons for this retrial to happen. So when you have this very specific reason for a retrial to be done, when they're in court, when everything's being revealed and things like that here, you mentioned how it's going to be selective on how the defense or the prosecution wants to kind of pursue things or push through things. Is there anything that you would surmise from the perspective of the prosecutor or the defense where they would just leave it out completely because it's already been handled, it's already been done, or is there a necessity, because these are new jurors, to cover everything and to include everything, even if it's not, I guess, necessary or not needed, considering what the previous decision was?
Sure. So the easiest answer to the question about, what you can do or what you have to do the second time around is everything. Because unless a jury reached a verdict the first time that was not disturbed by some sort of a appellate rule or what have you, if the verdict is simply not there anymore because of what happened with the first trial being either incompleted or reversed on appeal, then you have no ability to go into the second trial with any kind of a leg up as far as proving your case is concerned. You have a huge leg up in terms of knowing what the witnesses are going to say, but you don't have any prior rulings from that first trial, from any jury determination following you into that second trial. When we talk about proving a case in a court against a criminal defendant, the prosecution has to meet the elements of the crime, each element beyond a reasonable doubt. So the element for a murder, obviously, is there's going to have to be an intentional killing of another human being, and depending on the nature of the charge, there might be the intent requirement could be present or maybe not if it's an accidental killing. The point is that each element, the intent, the murder, the etc., has to be established at the trial where a defendant is convicted. It cannot be imported from a prior proceeding.
So everybody needs to essentially pretend like that first trial did not exist.
Well, that's the interesting thing. So I teach evidence as well. And one of the big things we talk about in evidence is inferences. An inference is simply figuring out that something must have happened because of other things that you know. So the typical inference we often use is, if it wasn't snowy on the ground when you went to bed, but you wake up in the morning and there's snow on the ground, we make an inference that it must have snowed overnight. Simple. But we're really concerned about those kinds of inferences when it comes to jurors. We really want to insulate them from making inferences that the law does not specifically support. And having had a previous trial is ripe with opportunity for jurors to start speculating. So, for example, I said before that the availability of that prior trial testimony is a huge advantage to both sides. Yes, it is. But in order to use that prior testimony at a second trial, somehow you have to communicate to the jurors that these witnesses have testified under oath before. And it's very difficult to do that, especially in a high-profile case, without the jurors figuring out for themselves, oh, I guess we're here for number 2 or number 3. And so one of the things trial judges always try to do in any kind of case where there is a retrial is, first of all, if you can, prevent the jury from learning about the fact that there's a retrial. Second, if you can't prevent them from learning that it's been retried, at least prevent them from learning why there was a need for a second trial. And then finally, instructing them that if they are aware, or there's reason to believe that they're aware of the existence of a prior trial or a prior jury determination, that they should not take any of that. They shouldn't speculate about what happened. And even if they know what happened, they should not factor that into their decision the second time around.
What I thought was interesting that you mentioned there is when you have to avoid them knowing why there is a retrial, which, to your point, you made it a little bit earlier, there can be a ton of different reasons. I mean, there could be the reason the person was not physically present as a witness. There could be the reason of not enough information, of too much. I mean, so I'm guessing there's dozens and dozens of reasons why there could be. If you can kind of explain why it's important to keep the jury in the dark on the specific reason for that.
Well, the best reason to keep the jury in the dark is because one of the most frequent bases for granting a new trial is something that happened in the first trial that shouldn't have. Somebody was able to testify about something that shouldn't have come in under the rules of evidence, or there were inappropriate statements made by witnesses or prosecutors that had nothing to do with the kinds of issues that we allow jurors to entertain when they decide guilt or innocence. So in the second trial, if jurors come to learn that something like that happened in the first trial, and they come to learn why it was reversed and what happened that caused it to be reversed, those jurors are going to be tainted by the very same improper evidence that led to the reversal in the first place.
When people are watching this is, again, it's a unique opportunity with the retrial aspect. What are some things that you would suggest that they do look out for? The thing is, as a journalist, we get very bare bones knowledge on some legal jargon, and I mean that as the most bare bones, but it is still more than some people know or understand. So what are some things that you would suggest people watch out for or listening to as we're watching through this trial that potentially is either a little different or something out of the ordinary than what they would normally experience?
Sure. Well, it relates back to one of the main differences in a retrial from an earlier trial, which is now all of the witnesses who already testified have now been kind of locked into their testimony under oath. A transcript is probably going to be available to everybody of that first trial so that those witnesses can be examined this time with reference back to that prior testimony if they try in any way to change their story. And because you are having here a trial that involves the two same parties, the same party on the plaintiff side, the state of Ohio, and the same defendant on the defendant side, every witness who gave sworn testimony the first time around, that sworn testimony can be introduced without the witness even attending live in person because of the way the prior testimony was preserved that protected everybody's rights. So that prior testimony, if it comes in, but not through a live witness, but rather through that prior testimony, it can either be done through a recording if the original testimony was somehow recorded, or it can be done by having literal actors play the parts of the witnesses, reading answers to the questions that were asked the first time around, and the questions will get asked this time by either the prosecutor or the defense attorney, but the answers will be given by someone who didn't actually say them the first time around, but they will be reading verbatim from a transcript of what was said. That's really interesting, Jeff, because as you can imagine, one of the main things that jurors look for when they're watching witnesses testify are signals of whether the witness is credible, whether the witness is believable. Body language, eye contact, shiftiness, discomfort. Those are signals that can indicate one way or the other that the witness shouldn't be or should be believed. Well, if you have somebody else playing the part of the witness by reading a transcript of prior testimony at the trial, that aspect of evaluating the credibility of the witness is simply unavailable. And so that's one of the other interesting aspects of trial testimony as well. Now, because this case involved, as I understand it, a confrontation clause issue because of the defendant's inability to participate live in the proceedings, they may be much more careful about staying away from that kind of prior testimony and forcing every witness to testify live simply because of the way things went down last time, but they don't have to.
Yeah, it is.
I want to interrupt that discussion, a very knowledgeable discussion about a retrial. The attorneys have returned to the courtroom, and there is a discussion now with Erica Stefanko, her attorney, coming out of the sidebar with the judge, obviously explaining we don't have our microphones on. We're not allowed to have the microphones on until the judge and the court reporter are in. That way that the client can have uninterrupted and private conversations. But something is being explained to Erica Stefanko as she is about to be retried in this love triangle / murder case. Remember, Erica Stefanko was married to Chad Cobb at the time. We're talking June of 2012. and her husband, Chad Cobb, was in a separate nasty custody dispute with his previous wife, Ashley Biggs. They had a daughter together. They were fighting out custody. And apparently that fight was ongoing to the point to where Chad and supposedly Erica Stefanko devised a plan where Erica would call. You have to keep in mind that Ashley Biggs, the other woman in this, she was a Domino's pizza delivery driver. So you have Chad and Erica devise this plan where Erica calls up a fake pizza delivery order to a vacant business. And when Ashley Biggs, who was 25 years old at the time, when she shows up to deliver that pizza, there is her ex-husband, Chad Cobb, waiting for her. He uses a stun gun on her and beats her to death. He then puts her body back in the delivery vehicle and drives it out to the middle of nowhere. This all happening in Summit County in the area of Greene, one of the suburbs of really the Akron area. And he leaves her body and her vehicle. He then calls up his wife, Erica Stefanko, that you see sitting there. She drives out, picks him up, comes back and helps him get rid of the evidence. And in fact, let's play a story from our Winnie Dortch, sort of a preview to this trial, as it looks like we're not set to get underway. We will not miss a single second of this gavel-to-gavel coverage, but this story from our Winnie Dortch will really help lay the foundation so that you can understand what we're about to launch into. Take a look.
This is Erica Stefanko in 2021. The 41-year-old was sentenced to life in prison for the murder of an Army vet. Ashley Biggs was found dead in 2012. The 25-year-old and Stefanko's then husband were locked in a bitter custody battle.
All I can do at this point for her family and friends is to pray for God's peace and comfort for them.
2 years later, Stefanko's conviction was overturned. An appeals court judge saying because her ex-husband Chad Cobb testified remotely from jail, this violated her right to confront a witness. This week, a new trial begins, her second go-around in this heartbreaking case. This unfortunate tragedy unfolding June 20th, 2012. Biggs was a Domino's pizza delivery driver in Greene. She was lured to a closed business in New Franklin. Police say Stefanko drove Cobb home where he washed off the evidence. In 2020, a family friend said in court Stefanko told her what happened that night.
She had dropped Chad off where the crime occurred and that she had drove off, and she never said where she waited for him. But she said that she had waited for a phone call from him to come pick him up.
Biggs' body was found the next day. Cobb was arrested. He was hiding in a wooded area behind a relative's home. Cobb is serving a life sentence. Stefanko is back at square one. And jury selection is taking longer than expected. Stefanko is sitting at the Summit County Jail on a $2 million bond. In Akron, Winnie Dortch, 19 News.
And so that really sets the table for where we are now. There is Erica Stefanko waiting for her retrial to begin. This is going to be a very unique experience. Normally we have in our gavel-to-gavel coverage, this is a brand new trial. This is the first time we're seeing evidence. This is the first time we're hearing a lot of the details on the case. And that's not the case. We know that Erica Stefanko was already found guilty in this case, sentenced to a lengthy prison term. It was only a matter of appeal and really a technicality. Had there been no COVID, her ex-husband, Chad Cobb, who was in prison, wouldn't have testified via video. He would have been there in person. So you'll have to see if, and obviously we heard from the Case Western Reserve University professor that says when you do a retrial, and since that was the reason the first case got thrown out, the first conviction got thrown out, you have to assume that Chad Cobb will be in court at some point to testify. And very interesting, and that was something I learned as we see all the parties are there. We're just simply waiting for the all rise and the judge to come in. But really interesting that anyone who gets back on the stand, they can't change their story. They can't deviate their testimony. And if at any time they do, they can be called on it. And what I find interesting and tough to do if this is a retrial, keep in mind, you have to keep from the jury that this case has already been tried. We get the all rise, and so let's take you now live into the Summit County Court for gavel-to-gavel coverage of deadly delivery.
Okay, we've got Doug here. Thank you, Doug. We're going to go on the record. This is the state of Ohio versus Erica Stefanko. Case number CR 2012-07-1887B. Good morning, everyone. The court was made aware last night of some issues with counsel for the state. Prosecutor Easter, go ahead. You can take it down when you're speaking. Yes, thank you.
Thank you. That is correct, Your Honor. Co-counsel Brian LaPrenzi was feeling ill all weekend, and yesterday he took a COVID test, actually 2, which are positive. He promptly called me, and I called your judicial attorney, Tristan, and we forwarded screenshots of those tests. I, in turn, took a COVID test. My test came back negative. I forwarded that to the judicial attorney, Tristan, as well. In all fairness, at that time, my head was hurting and I had pressure. I let the court and counsel know this morning. Throughout the night, I was coughing and my throat is scratchy and I am short of breath. I did come prepared to go if that was the route we were going to take. However, I did let the judicial attorney know I would ask for a continuance based on the ailments that counsel for the state, the positive COVID and my potential symptoms, and the fact that lead counsel is not present, Your Honor. The state asked for a continuance of approximately 30 days, Your Honor.
Why do you feel 30 days is necessary?
Your Honor, 30 days based on the guidelines that once you have a positive test, you have to quarantine for 5 days. I believe you must wear a mask for 5 days until you're symptom free. And then the other engagements that the state made the court aware of prior to trial starting.
So the state's not available. It'd be the state's requesting 30 days because of the state's schedule.
Correct.
Correct. Okay, I'll hear from defense. Good morning.
Good morning, Your Honor. Thank you. May it please the court. We're sorry to hear about Mr. LaPrenzi. We also hope that Ms. Easter is okay. We are opposed to a continuance, certainly of 30 days. Ms. Stefanko has waited a long time for this retrial. We're here today. We're ready to go. That said, we are not unsympathetic to illness, and especially an illness of this nature, which could potentially lead to juror infection and spread and continue the trial for a lot longer than 30 days. If the court is not inclined to start up right now, and again, the defense would understand why not, we would suggest and we would be okay with playing it day by day, keeping this jury impaneled, and should Mr. LaPrenzi and God forbid Ms. Easter get it and then test negative at that first available date after a negative test, assuming no other issues, we would ask that the trial start back up. So be that later this week or early next week, I think would be realistic. We would be fine with that.
So obviously, the court sympathizes, of course, with Prosecutor Easter and Prosecutor LaPrenzi. My other concern, and I am going to, when we bring the jury in, I am going to notify them only because we were all on a jury view Friday for, I don't know, approximately 3.5 hours in the same van. So I do want to let the jurors know. And again, the court's going to deny the request for a 30-day continuance. And if the parties are agreeable to this idea, what I would like to do is go day by day. I would ask Prosecutor LaPrenzi to test every night at 6 p.m., notify my judicial attorney of the results of his test, and then we would let the jurors know by 8 p.m. whether or not to report the next morning. I'm very concerned about granting a 30-day continuance when there's so much media coverage. And also, we've impaneled the jury. We've told them this would be 2 to 3 weeks, and I'm not comfortable putting their lives on hold, or the defendant who has a right to go to trial, and the defense is ready to go to trial today. Would the parties be agreeable to that? And as soon as we have a negative test or Prosecutor Easter is able to breathe better, we could move forward that next morning?
Yes, Your Honor, thank you.
That sounds reasonable to us, Judge.
Is that reasonable?
Yes.
Okay, I'm going to have Adam bring in the jury now. Is there anything else we need to put on the record before they're brought in?
No, Your Honor.
So I do want the parties to be aware the minute that we have a negative test, we're going to be ready to move forward.
Sure. We're ready.
And is everyone here feeling symptom-free at this point who is on the jury view?
The defense side is so far.
Detective Hitchings? Fine, okay. The court's also fine. Good morning, everyone. Okay, do we have all of our jurors? Wonderful, thank you. Go ahead and take a seat. Good morning, ladies and gentlemen of the jury. Thank you so much for reporting this morning on time. I know the weather's not great. We appreciate everything you're doing to make it here. The court did want to let you know there's been a situation going on. As you know, we all went on our jury view Friday. I think it was about approximately 3.5 hours we spent together on the bus going to 5 different locations. Unfortunately, the court was notified late yesterday around 8:45 p.m. that lead prosecutor Brian Laprenzi has tested positive for COVID. And I just want to let you all know that, obviously, because we were together. I think, Adam, we have masks in case anyone, if you want a mask, please feel free. Adam's going to pass those around. So did want to let you know that. And unfortunately, Prosecutor Easter is also not feeling well. She has not tested positive. She tested negative. That being said, what the court is going to do out of an abundance of cautious for everyone's safety, but also, within the guidelines of what we can do to not delay this trial. So unfortunately, we are not going to be able to move forward this morning. What I'm asking Prosecutor Laprenzi to do is to test every evening at 6 p.m. Once he has that test, either my bailiff or my judicial attorney is going to call each of you to tell you whether you need to report the next morning. The state has asked for a 30-day continuance, which I have denied. I'm not going to continue this case that long. You've already been impaneled. Obviously, you have to put your lives on hold, your jobs, your family every day. So we want to be very cognizant of that fact. So every night, we're going to have him test. We're going to call you immediately to let you need to know if you need to report the next morning, okay? And is there anyone else here who's feeling ill, just in case? Okay, not feeling great? Okay. So that is the plan now. Unfortunately, I'm going to have to go over again the admonition for what you need to do now that we're not going forward this morning. As you know, it's very important for you to be fair and attentive throughout the trial, and that includes all of our alternatives, of course. Do not discuss the case among yourselves or with anyone else. This includes family, friends, and the media. You must not post or read anything about this case on the internet or on any electric device, including cell phones. That would include social networking sites, blogs, Facebook, X, Instagram, Snapchat, any of the social media networks. Any such discussions, if discovered, could lead to a mistrial and would severely compromise the parties' rights to a fair trial. We've talked about that so many times. I know you all understand. Again, do not permit anyone to discuss this case with you or in your presence. Do not form or express any opinion on this case until it is finally submitted to you. Again, among yourselves, it's difficult to understand that you can't talk about this case with each other until it's finally submitted to you. But again, once we return, as soon as everyone is able to return, and we truly would not have stopped today unless they were truly unable to. Prosecutor Easter's having a hard time breathing, and without her lead counsel, it would not be fair to go forward. So when we do go forward, though, you will receive the opening statements, the evidence, and then the closing arguments and the law in that order. Again, you need to explain this rule prohibiting discussion of the case to your family and friends. When the trial is finally over, I will release you from this prohibition. And at that time, you may, but you are not required to discuss the case and your experience as a juror. That's an individual decision you can make at that time. Again, you're not instructed to talk with the attorneys, the parties, witnesses, or anyone else during the trial. Likewise, they must not talk with you. You must also not talk with anyone else about the case during your deliberations. In addition, you should report the outside source of information to the bailiff or the court at the first opportunity if anyone were to try to discuss it with you. As we've talked, these proceedings may be broadcast, photographed, or recorded by members of the news media. You must not allow this fact to divert your attention from the case or to interfere with your duties as jurors. Further, you are not allowed to talk to members of the media during the trial. So again, I caution everyone not to discuss the case among yourselves or with anyone else. Do not read, view, or listen to any reports in the press, radio, or television, and do not form or express any opinion on the case until it's finally submitted to you. And I know you've heard this multiple times, and you've been sworn in twice, taken an oath, so I know you understand the seriousness. So what our plan again is going to be is we're going to have Prosecutor Loprenzi test tonight. Adam or Tristan or Denitra will give you a call before 8 p.m. Just so you're able to plan your next day, okay? Do we have anything further from the state or the defense?
No, Your Honor.
Okay. Thank you so much again for reporting today. We unfortunately are going to conclude this morning. I know it's been an inconvenience to you all, and I sincerely apologize that you had to come all the way downtown and park and do all this stuff, but we really, really appreciate your service, and we'll be in touch every single night, okay? Okay, thank you.
Dan DeRose with 19 News. A major curveball, and the irony is not lost on this reporter. The reason we have a retrial to begin with of Erica Stefanko, the woman you saw there, is because her then husband testified during COVID from prison with a mask on. That's the whole reason the appellate court judge said that she should be given a new trial, is that he should have been in the courtroom, that her defense team should have had a chance to confront him in person.
Of what the court's ordered him to do each night? Okay, thank you, everyone.
Thanks, Judge.
Thank you.
And we are adjourned for the morning. So again, this is not what anyone expected. Let's hope and say a little thought for the health and safety of the lead prosecutor, who was supposed to give opening arguments this morning and tested positive twice for COVID in the last 24 hours. So the beginning of this trial is going to be delayed. You heard the judge say that on Friday they did discovery. They took the jury on Friday to the location of the crime. That's very common. That way, when they are discussing the location in court, the jury has a mental picture. They were there. They saw where the car came in. They saw the empty business. They may have even gone out to where the car and the body was ditched to show that area. And I really wanted to watch here as Erica Stefanko, and you see they have put a sweater over her hands. That is by design. She is clearly handcuffed. She has already been found guilty of this crime once. She has been put a $2 million bond while she sits in jail there waiting for this trial to begin again. So the fact that they put a sweater over her hands, granted the jury was already out of the courtroom, but you can't show it to a jury that a defendant could look guilty in any way. That's why no defendant is ever seen during a trial in an orange jumpsuit. Now, we see jumpsuits all the time in court, but that's for sentencing. Once the person's been found guilty, now it's time for the sentencing phase. If a sentence is determined by a jury, you will see the defendant in plain clothes. If there are arguments that are made, they can't, again, show the jury a defendant in a jumpsuit because jumpsuit says guilty, and that could persuade a jury on a sentencing. But if it is a judge sentencing, that's why we see defendants in orange jumpsuits. But again, a little bit of irony. This case is back in court because of COVID, and now we are on a delay because of COVID. The lead prosecutor testing positive twice for COVID. They were out on discovery with that prosecutor. The judge had to ask the jury if anybody was feeling ill. Apparently one indicated they didn't feel great. So this could be an issue. Thought it was interesting. The prosecution asked for a 30-day delay. The problem with that is you've already paneled a jury. You can't sequester that jury for 30 days. That would be impossible, giving up their lives for a month before the trial begins. You can't trust that a juror wouldn't start doing some research of their own on this case in a 30-day period. That would be an impropriety and would be cause for a mistrial. So the judge saying, no, we're going to take this day by day. The lead prosecutor must test every night at 6 o'clock, inform the judge's office if he is negative or positive, and then a phone call will go out to the jury by 8 o'clock that night on whether or not they have to report the next morning. Think about what a pain in the rear end this is for the jury. Your life is already in an upheaval. You've had to take time off of work. You've had to find new options for your children, daycare, that kind of situation. And now you're being told you'll find out every night at 8 o'clock if you have to come back and have your life get thrown upside down all over again. Very interesting delay. I've never seen this happen, but again, COVID is impacting a lot of items in our life. We're going to wrap this up. We are committed to gavel coverage. So when we know, we will let you know if the trial begins. That means obviously around 6 o'clock, we will be in touch with the bailiff or the judge's office to find out if the case will continue the next morning. So we are in delay and on standby. We're going to keep on it because we know this is a high-profile case with a lot of interest. When we start back, it'll be right here on our digital platforms. Until then, I'm Dan DeRose with 19 News. Have a good day. Stay healthy.
19 News is everywhere.